panels that they were very thought-provoking indeed. We can expect more of the same from our present panelists, who will help us examine the current trajectory of Canadian jurisprudence with respect to the fundamental freedoms of conscience and religion. How are those freedoms understood, and how fundamental are they? What warrants their curtailment or infringement? How do we decide whether an infringement is or isn't trivial? Questions emerging from prior deliberations in our morning panels will receive further consideration here, together with the question of how far the law's trajectory coincides with public expectations and with the rapidly changing society, and how far it should coincide as well. Permit me to introduce first our special guest, retired Justice of the Supreme Court, the Honorable LeBel. It is a great privilege to hear from him and to be made the beneficiaries of his long experience on the court. He was appointed to the Quebec Court of Appeal in 1984 and to the Supreme Court of Canada in 2000. He received an LLD honoris causa from LeBel University in 2001 and from the University of Ottawa in 2010. And of course, he sat on the cases that were the instigations and inspirations for the morning panels. He is the subject of a new book of essays devoted to his legal legacy called The Dignity of Law. That book is divided into 4 sections: Justice LeBel the Man, Justice LeBel the Civilian Jurist, Justice LeBel on Law and Public Policy, and Justice LeBel on Fundamental Principles. Well, we're interested in each and every one of those, but before we hear from him, permit me to introduce also the rest of the panel, for whose presence we are also grateful. Howard Kislowicz, a McGill alumnus, is an assistant professor at the University of New Brunswick's Faculty of Law, where he teaches constitutional law, administrative law, and multiculturalism and the law. He also serves as clerk to Justice Gilles Letourneau at the Federal Court of Appeal. He was a recipient of the Alan Marks Medal for Best Thesis in the University of Toronto's Graduate Law Program, and in his UNB post of the Faculty of Law Teaching Excellence Award. He has published his work in leading law journals and presented his research at national and international conferences, including the Harvard-Stanford International Junior Faculty Forum. Professor Kislowicz has also written several important articles on religious and conscientious freedom. Dr. Raymond de Souza is the editor-in-chief of Convivium, chaplain at Newman House, the Roman Catholic Center at Queen's University, a parish priest, and a senior fellow at Harding's, a think tank dedicated to the renewal of North American social architecture. In addition to writing for the National Post and the Catholic Register, he is an able and popular analyst not only of Canadian culture, but of Vatican culture, and has but recently returned from Rome's Synod on the Family. He was there when I talked him into coming here, in fact. Professor Hui Kong, who's just come in and who warned me that he was involved in various activities over at the Faculty of Law, I think curriculum related, if I'm not mistaken, and would be arriving just at this moment, hence my impeccable timing.
You're welcome.
Is Associate Dean Academic in the Faculty of Law, works in constitutional law, comparative law, administrative law, and municipal law. From 2002 to 2003, he was clerk to Justice Deschamps and Le Dubé at the Supreme Court of Canada. He taught formerly at Queen's, where he was a recipient of the Queen's University Law Students Society Teaching Excellence Award. In 2013, here at McGill, he received the John Durnford Award for Teaching Excellence. We're putting his skills to work by inviting him to offer a sort of summing up, as it were, that will assist us in the transition from what is said by Justice LeBel and the other panelists into our Q&A period. And we're grateful that each of you would take time from your very busy schedules. The other two on the far end, of course, have come from much further away, but all our panelists today are people with an awful lot of responsibilities, and once again, we're very grateful that you would take time to be with us. So as earlier in the day, we asked panelists to confine themselves in the first instance to 12 minutes, but we have requested that Justice LeBel take some extra time, as we're all keen to hear from him with his unique perspective on the trajectory of Canadian jurisprudence with respect to the fundamental freedom of conscience and religion. Thank you, Justice LeBel.
Thank you, Professor Farrell. Ladies and gentlemen, I wish first to tell you that I much appreciate this opportunity to be with you to discuss some key critical issues in current Canadian law. I think we were invited to address freedom of conscience and freedom of religion. Where are we headed? I will not attempt to give you a review of the case law. I think it would take just too much time. It would detract from really the meaning of what we are trying to do. I think I will rather try to give you my understanding of the journey into which we embarked, especially since the advent of the Canadian Charter, and then I will perhaps try to peer into the future. I'm not a prophet, I'm not a seer, but I think it would be interesting to discuss what are the issues that might be coming up in respect of freedom of religion and freedom of conscience. I think I use the word journey. Before the Charter, I think there was a public law regime. I think there was such thing as freedom of religion, freedom of conscience. There was case law on those issues. But those short words in Section 2A of the Canadian Charter started us on a different journey. Freedom of conscience, freedom of religion. And here we are in 2015 with a body of jurisprudence, much discussion, key and sensitive social and moral issues that all came up through this to the channel of discussion about freedom of religion and freedom of conscience. And at the same time, as this is in the Charter, it cannot be entirely separated from, I think, the development of other rights, from the way the Charter as a whole was interpreted and applied. In just a few words, I would say that what happened, the work of the courts since the advent of the Charter has really to try to determine and understand what is the meaning of freedom of religion within what is considered to be a secular, neutral state. What does that? What is the nature of freedom of religion, and in the end, what is perhaps the nature of this secular state? When litigation about the Charter started, I think both in respect of freedom of religion, freedom of association, and perhaps other rights like freedom of expression, I think the trend was first to see those rights and freedom of religion and freedom of conscience as essentially individual rights. The Charter was, in a way, for people, for individuals within society, and not primarily for institutions, for groups. And this, I think, colored the interpretation of the guarantee of freedom of religion. From the start, I would say, from Big M, I think the gist of the interpretation of the Charter was this is an individual right. Freedom of religion belongs to the individual, and we will have to look primarily at the understanding of religion by the individual, and not so much at asking ourselves what is religion. I think the courts adopted a very broad, interpretation of what was religion, but it was mostly focused from the start on the belief of the individual. It was the right to believe or not to believe to entertain a belief system about the nature of the world, its relationship or its lack of a relationship with a supreme being or a supreme force, but it was focused on looking at what the individual thought. And in this development, I think that the clearest case was probably Amsterdam, which is well known, which is about the famous Souza case, and the test that was developed by Justice Kislowicz for the majority in this case was mostly about not asking what were the teachings of the particular faith to which the individuals claim to belong, but rather focused on their understanding of that case and the sincerity of the belief. And freedom of religion was viewed as the right to entertain those beliefs and to have them protected against the interferences by the state, or even in that case by the management of a condominium. This could be done under the Quebec Charter. It was very much about asking yourself what does the individual think, and once you had reached the stage of establishing that you had some beliefs, that those beliefs could be considered as religious, although there was not much consideration about what was really religion, and you had proved not minimal interference with your faith, with what you thought were your rights, you were entitled to make a claim of a breach of freedom of religion. This was basically the trend until recent years. I think it reflected a certain view of the relationship between believers and the state. I think it was concerned mostly about, I think, protecting and creating a kind of private state, of a private space that would belong to the individuals. It could be a private state where the essence of their personal beliefs would not be interfered with. But this approach, I think, could not meet, I think, the full richness of what is the meaning of religion and conscience. So there developed also new problems about other aspects of the relationship between state and individuals, which in some ways connected to the institutions, to the collectivities that individuals had to create in order to protect their right to freedom of association. And at the same time, also the law had to ask itself how far could it accommodate the beliefs, the moral value systems of religious people in the context of a state that viewed itself essentially as secular. So, on the one hand, I think there developed, I think, a certain concern about the respect for the collective aspect of freedom of religion. Successive cases, I think the gay marriage reference mentioned it. Rotarian did more recently. I think Loyola is a clear case of this. The Saguenay and Mouvement Laïque Québécois are also concerned about this. That religion without being completely defined included a right to establish communities of faith, to maintain them, develop them, and have them protected against interference by the state. But at the same time, if the law accepted the existence of those communities of faith, it had the concern about the relationship between those communities, the public space in the state, and the impossibility to a certain extent to completely accommodate the views of every community. It could not impose, I think, purely secular views on in the internal life of religious groups, but at the same time, it would not be possible to maintain a public space open to everyone, a public space where full democratic discussion could take place if the state undertook to support particular religious groups. So I think the effort over a number of years has been to operate a kind of reconciliation between different groups, different worldviews, in order to allow them to work together, to live together within a democratic society. This affects solutions about I think education institutions, about the orientations of the legislation of the state. It affects, I think, even at some points, freedom of expression, which must be upheld at times, even at the price of some discomfort within groups. But as I understand what happened, it was I think an effort to shape, I think, the outline of what could be a neutral or secular state, and of a proper relationship between religion and the general life of society. As it was, I think, a difficult undertaking. I do not pretend that the courts manage, or the law indeed manage, to reach a perfect solution, but it's a search to try to find the least imperfect way, to frame the least imperfect world in order to allow people with very different views, very different opinions, to be recognized, acknowledged to the full extent of their abilities, to gain respect, and to gain the ability to participate in the life of society. So, to a large extent, the development of freedom of religion was a long interrogation about the nature of our society, the nature of the state, and how could we relate with the state and relate with others that do not share the same view of the world, of its future, of its priorities. But in the meantime, I think this journey, I think, was probably omitted some important issues. For example, what is freedom of conscience? It's what's amazing, and I did some research before coming here, and on the occasion of other cases. Really, we have very little about what is freedom of conscience in the law. And at a time when we are starting, given certain recent development, to ask ourselves, what is freedom of conscience? What is this particular right? Why was it somehow subsumed into freedom of religion? I think from the start, I think freedom of conscience somehow disappeared within freedom of religion. I guess that given the nature of the issues that came up before the court, there was a kind of assumption that if we were dealing with religion, we would be dealing with conscience, and that we might do. You can perhaps find a few mentions, a few comments, obiter or not, in judgments and freedom of conscience, but then rather little about it. And then we perhaps, and in our jurisprudence, in the jurisprudence of this country, we talked a lot about religion. We gave rather broad definitions of religion, but we didn't have to really inquire in any depth into what is religion, what are the components of religion. Is every system of belief, religion, what really falls within the guarantee of freedom of religion we have, I think essentially based on Amsterdam and some prior cases, very flexible definition, but are we sure that it would work in all cases? And also, it was a definition focused on the individual. But there, we have been going through, I think, a kind of, I will not say revolution, but a kind of significant change in how we tend to view the Charter. I would say that not only in respect of freedom of religion, but in the case of other rights, like freedom of association, there has been this rediscovery that, in a certain way, no man is an island unto himself. We are often, most of the time, connected to collectivities, connected to groups, and in the case as of religions, of religious groups, the question becomes: is it possible to protect freedom of religion, or to define its borders without extending a form of protection to the structures, to the institutions? We're not there, but I think there are indications that in some way, you find it in the dissent, in the concurrence in Loyola, that there will be some sort of at least derivative protection of institutions as necessary to protect and maintain freedom of religion. And in the future, we will have also to address the limits. How do you fix limits to freedom of religion, to freedom of conscience? I think we have a very well established system of limitation of rights under Section 1 of the Charter, as you know, the Oakes test. But it was often pointed out that the test is very flexible, and I accept it. It's essentially a contextual text. It's a test that is about proportionality between purpose and means, and in the end, in the context of constitutional litigation in relation to fundamental rights, it means that some contextual balancing must take place at a final stage. And I've read often criticism about the system, and I've seen it at work, and it would be difficult to determine firm set principle. I will give only a couple of examples. In the Uterian case, the Chief Justice and the majority found that the obligation to give photo of oneself to get a driver's license was not an excessive, I think, interference with the freedom of religion. In my dissent, I found that it was excessive, and it would have been difficult to determine what kind of principle we were really applying. We just felt differently about the weighing of the factors. And if I look at what at the niqab case in court, I think we split, I think, 3 ways. I think the majority found that being allowed to wear niqab when giving evidence in court should be, in the end, left to the trial judge, who would do the proper balancing. In my case, I felt that the impact on defense rights was such that I thought that the niqab should be removed in court before giving evidence, and Justice Abella really felt that the right of the person wearing the niqab should prevail. I do not know whether it will be possible to develop clearer principles about the application of Section 1. I'm far from convinced about that, because again, it's often based on the facts, on the context. Perhaps some lines of authority will develop as the jurisprudence goes, but it carries the risk of leaving much in the hands of the judges, of the adjudicators at other levels. And then we will have, and I return to this, to come up, I think, with a clearer separation of freedom of conscience and freedom of religion. We will have, I think, to reflect on what is freedom of conscience. Does it have a secular content? If this is so, what kind of systems of opinion, belief, secular in nature, will trigger the application of the guarantee? Does it apply to freedom of religion? And if we get into the nature of conscientious objections, what should be its limits? It's a very long journey, the journey that was undertaken a number of years ago. I think it probably didn't start with the charter. It started with the historical developments that go back many centuries ago, and I think we're at but a moment of this journey that seems to be happening in an effort to develop a society in which everyone can play its full and complete and part, and at the same time where everyone will have to accept that it's impossible to create the perfect society. If we attempt to create the perfect society, we see things happening as they have been happening during the last few days. We name religious people may not be entirely happy or satisfied with the development of the jurisprudence by the court, but having taken part in some of this development, I think I must at least say that I have had the sense that I was taking part in a serious effort to develop a life open to everyone, to develop, to give meaning and content to what it is to live in a democratic society, and in an effort to make everyone, I think, welcome, while at the same time acknowledging that it was not possible to satisfy every group, every opinion, that even if there was no formal hierarchy of right in our charter, that there were at least some more basic rights. I would say the right of all persons to be treated equally, the right of persons to their autonomy, that rights should be interpreted in such a way that they would foster fuller participation in society. It's an effort, I think, that it's in common to society. I do not know where this will end, but it was a challenge worth trying to address. Thank you.
I want to begin by saying I'm delighted to be back at McGill. I spent quite a few hours as an undergraduate in the Brooks Reading Room across the hall, and I'm delighted to see that there is still a glass bowl of Werther's Original available to snack on while you're studying, which was, I think, what brought me there in the first place. And I also wanted to be sure to thank Professor Farrell for the very kind invitation to come and be with you today, and in particular to share on a panel of such distinguished guest thinkers. So I just wanted to acknowledge my gratefulness for the occasion. And I want to address the big theme for the panel is freedom of conscience and religion, where are we headed? And that's a very big question. And I want to suggest a way at that question by looking at something very small. And I hope by the time I'm done, I'll have persuaded you that it is not trivial, despite being something small. So as you may know, anyone seeking to advance a claim of religious freedom under Canada's Charter of Rights and Freedoms, or indeed under Quebec's Charter of Human Rights and Freedoms, must establish that the interference with their sincerely held religious belief or practice is an interference that is more than trivial. So this is a fairly well-established principle of our jurisprudence that is often not looked at with much of a critical eye. And I'm going to suggest that today, in 2015, there is actually a good reason to start thinking about the non-triviality requirement more critically. And then I'll close by suggesting that the ambiguity surrounding this notion of triviality is actually perhaps an emblem or a microcosm of the ambiguities that surround resolution of religious freedom disputes more generally. So why is 2015 a good time to start thinking about triviality? Well, we spent a good amount of time this morning talking about the Supreme Court's decision in Loyola, and there was also mention made of the other religious freedom case of 2015 made by the Supreme Court of Canada in the case of the Mouvement Laïque Québécois and the city of Saguenay. So as you know, in the first case, the question was the constitutionality in part of Quebec's ethics and religious culture curriculum. And in the second case, the constitutionality of the the religious freedom requirements related to a municipality's practice of opening its town meetings with the recitation of a prayer that invoked God, with the mayor and council members opening and closing the prayer with the sign of the cross. So one of the things that ties these cases together, in fact, is this notion of triviality. In fact, at the Quebec Court of Appeal, in both cases, the Quebec Court of Appeal held that to the extent that there was an infringement of religious freedom, it was no more than trivial. It was a trivial infringement of religious freedom. In Loyola, the finding was based on the determination that the ethics and religious culture program was only one course of many, and every school, Loyola included, was free to create additional courses that might last even twice as long in terms of the credit hours as the ethics and religious culture curriculum. So to the extent that there was an infringement, it was trivial. In the Saguenay case, the Quebec Court of Appeal held that the infringement was trivial because the prayer only lasted 20 seconds, and Mr. Simoneau, who was the claimant in that case, did not show himself to be particularly sensitive, so to the extent that there was an infringement with his religious freedom, it was trivial. Now, of course, the Supreme Court of Canada held the opposite in both these cases, but it's very difficult to tell exactly from those decisions, I think, where the line between triviality and non-triviality exists. So the Quebec Court of Appeal says trivial in both cases, the Supreme Court of Canada says non-trivial in both cases, but what tipped the scales? Where did the claim cross the line from the non-trivial into the trivial? So to look more closely into this requirement of non-triviality, it has been cited consistently since a case called Jones, a 1986 decision of the Supreme Court of Canada, where Justice Wilson was the first to enunciate this idea that we shouldn't trivialize the Charter by allowing trivial claims to be made in its name. We get a little bit of an example of a flavor of what a trivial infringement might look like in a decision of the same year called Edwards Books. Now, this was a case about Sunday closing laws in Ontario. And in that case, Chief Justice Dickson, on his way to making his determination, suggests what a trivial interference might look like. And his suggestion is that a modest sales tax, extending to all products, including those used in the course of religious worship, might be considered an infringement of the religious freedom right that was a trivial infringement. I think I agree with that. I think that's right. That if there's a general sales tax and it's not huge in nature, and you have to pay it when you buy articles that you use in your religious practice, that would be, to the extent it's an infringement, is a trivial infringement. But the more I started to think about it, I'm not sure which aspect of that example is what makes it trivial. So, for example, if there was a tax that was only on religious articles, or articles used in religious practices, I think we would be more suspicious of a claim that that was a trivial infringement. At the same time, if there was a tax that applied to everything, but it was a very large tax, and there was some evidence in a particular case that it was very expensive to buy a particular religious article, and the tax made it prohibitively expensive for practitioners of a particular religion to meaningfully carry out their practice, again, I think we would be suspicious of a finding that the infringement was trivial. So I think it's some interaction of the modesty and the uniformity of the tax in Chief Justice Dickson's example that makes us think it's trivial. If that's the case, it might be a difficult example to analogize from. If there's an interaction of two features, that is what makes it trivial. We get further elaboration on this concept of triviality in the Hatarian Brethren decision, which has been discussed a few times already today in 2009. And there, Chief Justice McLaughlin holds for the majority of the court that a trivial infringement is one that does not threaten actual religious beliefs or conduct. Now that adds a few more words, but I think it might only delay the analytical difficulty. If instead of looking for triviality, now we're looking for actual threat, I think we're having the same debate in different words, and I'm not sure it helps us draw the line any more clearly. So other than that, there haven't been a lot of Supreme Court decisions on this notion of triviality, but there have been some lower court decisions, and I thought I'd give you a few examples where courts have found that to the extent there's a religious freedom infringement, it is a trivial infringement. So one is a case called Badisha, a decision of the Ontario Superior Court of Justice, where the question was whether it was a religious freedom infringement that a Sikh man who sought an exemption from Ontario's motorcycle helmet law was denied that exemption. So the claim was, as part of my religious practice, says Mr. Badisha, I must wear a turban. I can't wear a helmet and a turban at the same time. I'd like to ride a motorcycle. Can I have an exemption from the motorcycle helmet law? The exemption is denied, and the court holds that to the extent that Mr. Badisha's religious freedom is infringed, it is a trivial infringement. In part, they arrive at this conclusion by focusing on the purpose of motorcycling rather than on the purpose of wearing a turban. So the court says, you might want to wear a turban, and that's fine. And the fact that you also want to ride a motorcycle has nothing at all to do with your religious practice. So to the extent that your religious freedom is infringed, that is trivial. A similar kind of reasoning can be seen in another decision from Ontario called Welsh. Now this one is straight out of Law and Order. The police organize a sting operation where some of their officers pose as Obeah men. So spiritual advisors, practitioners of Obeah, which I don't know very much about, but is an assembly of spiritual practices originating in Jamaica. So some of the officers pose as Obeah men, and in the context of posing as those characters, they get confessions from some members of that community about other crimes. The accused say that the use of an undercover officer as an Obeah man is a violation of their religious freedom rights. Again, the court says, well, it's not like the accused were actually in a context of a confession, as we might imagine in a religious context. It's just that they were talking to a member of their community who happened to be posing as an Obeah man, so the purpose of their communication with these undercover officers was not itself religious. Therefore, to the extent there's a religious freedom of violation, it is a trivial religious freedom violation. A final example that I'll mention, and there are others in the case law, but this one goes in a slightly different direction, is a case called Veffer that was decided by the Federal Court of Appeal. Now, at issue in Veffer was whether Mr. Eliyahu Veffer could have on his passport his place of birth listed as Jerusalem, Israel. So, Passport Canada has a particular policy with respect to Jerusalem. It doesn't apply to any other disputed territory in the world. For most disputed territories, it's the passport holder who gets to decide what shows up as the country after the comma. But with respect to Jerusalem, no matter what you ask for, they're just going to put Jerusalem. So you can't have a passport that says Jerusalem, Israel. You can't have a passport that says Jerusalem, Palestine. It just says Jerusalem. So Mr. Veffer says, that's a violation of my religious freedom. I identify as a Jew, and it is part of my religious belief that Jerusalem is the eternal capital of Israel. To the extent that you're preventing me from having that on my passport, it's a direct interference with my sense of identity. And in this case, the court says, to the extent that there's an infringement, again, it's a trivial infringement. You don't have to open your passport very much. You don't have to get your sense of identity by looking at your passport. So it's really not that big a deal. The common logic I want to suggest from all these cases is something of a reasonableness test. All right, the court is saying, and this is, I think, suggested by the very structure of the way the ideas work together. The court is suggesting we recognize that there's an infringement or an interference with your religious practice, but it really shouldn't have bothered you that much. If you were a reasonable person, you wouldn't have actually taken this to court. And I think I understand the impulse not to trivialize the Charter or the Charter of Human Rights and Freedoms here in Quebec. But at the same time, I think there's a deep tension with the way that the court analyzes the other parts of the infringement test for religious freedom. So as we've heard in the Absalom case, the approach to religious freedom is very subjective. It is entirely up to the believer to establish a sincerely held belief that has a nexus with religion that incorporates a particular practice. And the court said even in Absalom, courts are ill-suited to make determinations between mandatory and voluntary practices. So we're going to just include all religious practices, whether they're mandatory or voluntary, under the rubric of religious freedom. And I think there's good reason for that, right? Courts are not necessarily the right institution to be making those kinds of decisions of religious doctrine. I'm not sure what changes when we move from assessing the intensity of an obligation to assessing the intensity of annoyance or irritation that a person might have felt by the interference with that logic. My concern is this notion of triviality, I think at current, is under-theorized, And the risk is that we end up, in the words of Tom Waits, creating a jurisprudence where the large print giveth, but the small print taketh away. That there's something of an incoherence in the highly subjective take on what counts as a religious obligation to the reasonableness-based test of how much you should be bothered by it. So how do I think that this is emblematic of the larger discussion of religious freedom in general? Well, I think to the extent that there's an ambiguity, it stems in part from what Benjamin Berger at Osgoode Hall Law School has observed is a cross-cultural encounter that happens in almost every religious freedom case. So there's at least two different kinds of cross-cultural meanings that happen in religious freedom cases. First, the culture of Canadian legal thought is meeting the culture of a religious, of a particular religion or religious thought. And second, the judges on the bench may have had little exposure, little if any exposure to the particular cultural practices that are being assessed in each case. And any time you have a meeting of cultures, and here there might be two going on, there is a potential for ambiguity and a difficulty in resolving these kinds of tensions. The categories of one cultural system may not line up with the categories of another. In terms of where are we going, well, maybe there's a way of reading the 2015 decisions as an increase in the Supreme Court's practice of humility or self-awareness. That is, the reticence of the courts in both Loyola and Saguenay to label the infringement as trivial might suggest that the court is worried about losing the perspective of the practitioner in each of those cases. So they back away from using this triviality requirement and do most of the analysis under Section 1, where despite there being some objections, as Justice LeBel just mentioned, at least things are more out in the open, more explicit. I think if it's true that there is a trend away from relying on findings of triviality, and I think that's still an open question, then the likelihood is that there will be an even heavier leaning in the future on Section 1 or proportionality analysis in order to determine religious freedom rights in infringement cases. And where we're headed in that particular direction, I think, comes from Loyola, where there was an identification by Justice Abella for the majority of three core national values that I think will be significant in guiding courts' analyses in the future under Section 1. And these are the, perhaps related to those that Justice LeBel just identified, equality, human rights, and democracy as core national values for guiding the proportionality analysis. I'll leave my comments there and be interested to discuss more soon.
Thank you very much.
Good afternoon, and thank you, Professor Farrell, for the invitation to come from Queens to McGill. We're united by a press that publishes his books anyway, so and it's an honor to be here with Justice LeBel. I've often spoken and written about Supreme Court judgments, decisions, sometimes critically. But I've never actually had a Supreme Court justice who wrote some of his decisions beside me, so that's sort of, it's a novelty worth commenting on. I borrowed some of his paper beforehand, so now I have a legal pad from an actual Supreme Court justice. If you were a saint, that would be a second-class relic, but I'm not sure. I'm not a lawyer, I never went to law school, I'm not sure what they...
It's a legal pad from a lawyer.
Oh, just a lawyer, no longer a justice, he says, so...
Doesn't come from the
okay.
Supreme Court.
Very good. No Supreme Court letterhead here. I want to make 4 points regarding this question of the status of freedom of conscience and religion. The first one is general, the other 3 are related to 2 cases that we've been looking at, the Loyola case and the Carter case. So the first point is on sort of the status of freedom of conscience and religion and where it comes from. The starting point for Christian reflection on the political orders, the gospel injunction, that there are certain things that do not belong to Caesar. That is, regardless of the claims of the law, even if procedurally proper, there are certain things that don't belong to the state. And that's why there can be a concept of something's an unjust law, a law that's passed properly but is unjust. And the classic formulation, actually, of this in the Christian political theology tradition is St. Augustine puts it very vividly Without justice, what is the state but a band of thieves? So the state can actually be, even though it's the author of laws, a lawless brigand. And not only, of course, the legislative and executive branches. It's possible, even for an esteemed bench of judges, to be a band of thieves without justice. Now, if you don't like Augustine's formulation, because it's rather aggressive in a certain sense, the principal formulation of this principle in our time is actually from Martin Luther King Jr. in his letter from a Birmingham City jail, 1963, where he quotes both Augustine and Aquinas, that a law that is unjust does not have the force of law. So the question then becomes, where does this standard of justice come from? If the law itself is not its own standard, if a law that's properly passed procedurally can be unjust, then where does the standard of justice come from? It cannot be sufficient to say that only the positive law furnishes its own criteria of justice. Our charter, Canadian charter, acknowledges this in its language about the principles of fundamental justice. Things have to be decided in a court of principles of fundamental justice which are not specified. Completely anyway. So just to limit myself to this point at the outset, it is precisely religious and ethical traditions that furnish not exclusively, but effectively, those standards of justice against which the law must be measured. And therefore, jurisprudence ought to have an ally, not a rival, in the religious traditions. So that's just a sort of preliminary point about working these questions out, secular jurisprudence vis-a-vis freedom of conscience and religion. The following few points relate to some of the issues raised by the two cases we're looking at. The second point, I suppose, is that religion is a public good to be protected by the state. The reason that we have freedom of conscience and religion is because this freedom is thought to serve the common good, like the other fundamental freedoms. We have protection for freedom of expression, freedom of association, etc., because they contribute to the common good. They're goods. They're not neutral things, and they're not dangerous things. Although anything can be abused, obviously, but fundamentally it's a good. And because this good can be threatened by the power of the state, this freedom is therefore protected in our charters and our constitutions. If we borrow the American language, which is not our language, but the American language of separation of church and state, I mention that because often these debates are using that language even though it's not our constitutional tradition. It's because the church, or more broadly, religious practice, needs protection from the state. It's a good that needs to be protected from the state, not the other way around. I think this morning Janet Buckingham mentioned the Magna Carta, 800th anniversary year. That's why the first provision of the Magna Carta, she reminded us, is the liberty of the church. And we need therefore to look at the fundamental disposition of the courts toward the practice of religion. That's an emerging issue. Leaving aside the particularities of the Loyola case, what troubled me about it was that its fundamental disposition towards the practice of religion was, I think, at least restrained. The default attitude appeared to be that the state is the primary custodian of the common good, and it is obliged to treat religious believers then as a distinctive group that needs to be tolerated. Its rights need to be respected. Loyola was not asking, as Paul Donovan mentioned, for an exemption or accommodation. They were arguing that, in fact, they were making a contribution to the common good, specifically the one that the Quebec government was asking for. They were arguing more broadly that their religious teaching was in and of itself in favor of the common good. That religion serves the common good. Now, the Minister of Quebec, the Minister of Education of Quebec, disagreed, saying that by the fact that it was confessional made her suspicious, thinking it was a danger. There is, I think, a minimalism about religious liberty in the Loyola case, especially the majority decision, that the state can go as far as it wishes, save only for the gross violation of compelling a Catholic school to be neutral about the teaching of the Catholic faith. That's pretty thin rule. Reflective of a suspicion that religion may indeed be a threat to the common good, tolerated only as far as respect for minority rights requires. Behind that suspicion of religion is the difficulty, which was discussed in this morning's panel, that it's very difficult to reconcile the idea of religion as a public good with state neutrality between belief and unbelief, between religion and irreligion, between faith and atheism. The tradition of state neutrality between religions is not applicable in the same way as the state neutrality between religion and irreligion, or between faith and atheism. In relation to the other fundamental freedoms, this court begins by acknowledging that it serves the common good. For example, when a court has to decide about whether sealing court records or not, the default position when the media lawyers arrive for disclosure is that it's good. Freedom of the press and the access of the press is a good. And only if you can demonstrate that it's dangerous to some other good does it need to be restricted. The bias is usually in favor of the protected freedom. Not necessarily in the court decision, but certainly in the Quebec Ministry's approach, that was not the idea that freedom of religion was a contributor to the common good. And although the court did not agree fully, obviously, with the Ministry of Education, I think there was a kind of minimalism there. Maybe in the discussion we can return to the question of freedom and conscience and religions. I think it's very applicable here to the question of religion as a common good. The entire Loyola process, despite its apparent victory at the Supreme Court, in my view, some of my friends disagree, was largely a disaster for religious freedom in Canada. That it was not a complete disaster, I acknowledge, and that was celebrated by some. Itself an indication that the climate was rather chilly. It was largely a disaster because in order for a single school of venerable tradition, of high public esteem, to secure the right to teach what it had been teaching already, in conformity with its own raison d'etre, it had to litigate for years to get only a very limited vindication by the High Court. Forgive me if I'm not impressed that Loyola had to go to the Supreme Court to discover whether or not a Catholic school should be neutral about teaching Catholicism. That reflects a hostile environment to religious liberty. That's not the court's fault that it got all the way up there. In this case, by the governor of Quebec, it was only limited in part by the court. My third point is that about a public philosophy on these issues of conscience and religion in which people are left alone with their rights, and this turns on the Carter case. It's a legitimate question to say, why should society at large care about the rights of religious believers individually or in common? Should it not be sufficient that the state provide for the common good? The reason that society at large should care about this is that the bureaucratic state by itself is not capable of providing individuals with everything that they need. Perhaps rights, but not, for example, a network of relationships in which they can love and be loved, be cared for and supported, find meaning and flourishing. At the heart of the Carter decision is a very bleak, I would say astonishingly bleak view of the human condition. There must be a right to assisted suicide because the court ruled unanimously in this case. If people think that there will be no one to help them commit suicide in the future when they need it, they'll be forced to commit suicide earlier than otherwise would be desirable. It's truly astonishing to me that the court would think that the right to life must include the right to assisted suicide because the default alternative would be premature suicide. The idea that the sick and the suffering might find support in family, in friends, in civil society, to desire to continue living or to have their suffering ameliorated, does not figure greatly in the logic of Carter. The court leaves, in fact, the sick and the suffering alone with their rights, and therefore, all it can offer them, really, in this plight of their suffering, which is real, is the right to end it. And its vision does not include those associations, religious ones, which would be amongst them, that might alleviate it. In practice, it is religious associations and religious believers who often provide such support. We're seeing this in a different context in the refugee crisis. Jurisprudence that circumscribes the scope of activity of religious believers and associations in our common life moves toward the bleak vision of human society that we find in Carter, citizens left alone with their rights. Finally, my fourth point relates to the expression of the public will and the role of religious associations and religious believers in that. I think it's obvious, it's been stated before, that the values and worldviews, metaphysics as it is, as it were, of particular cultures cannot be neutral. I would further say that those are largely shaped, although again not exclusively so, by religious beliefs and traditions. The issue of what constitutes a societal consensus arose in Carter. The court had an evident problem in Carter, namely that in order to overturn Rodriguez, the court had to find some reasons to do so, aside from saying that simply the court had changed its mind. It could not find such a justification in the logical place for social expression concerning the law, the parliament, or the legislatures, because in this case the parliament had repeatedly refused to change the law, upheld by the court in 1993. So in Carter, the court appointed itself an arbiter of cultural consensus, and then declared the cultural consensus had changed sufficiently to invalidate the particular provisions of the criminal code. Where in our constitutional system does the diagnosis of the cultural consensus, where is that assigned to the courts? This is very worrying for the future of conscience and religion, freedom of conscience and religion, on two grounds. On one hand, we have the displacement of religious traditions in forming or shaping culture. On the other hand, we have the courts who will determine the rights of religion, both individually and in common, depending in part on whether it conforms to a cultural consensus, which in turn is determined by the court itself. That is not religious liberty that is recognized. That is rights that are a gift to be given or to be withheld by the court. That worries me. Thank you.
So I think in all of the presentations we see, I think two broad kinds of concerns. Right? So on one hand, there's concern about an appropriate balance. Right? That is, how should we balance certain kinds of interests against one another? And in addition, we have a second concern. Right? We can call this second. This first concern is a concern about balancing. A second concern is a concern about institutions, and in particular, the institutional role of the court. Because what we're discussing here is not religion in the abstract, right? We have great experts talk about religion in a religious context. We're not talking about faith standing alone within communities of faith. We're talking about faith within the viewed through the lens, as Father Souza puts it, through the lens of law. And one of the key questions when we address questions of law is this question about what role should legal institutions play? And in this context, the institutional role of the court. So let me start with Justice LeBel's extraordinary presentation, which was an amazing overview of freedom of religion. You now no longer have to go to law school if you're ever thinking about it. You're done. That's all you need to know. And there is a concern here that Justice LeBel raises about how do we balance the interests, the beliefs of religious communities against the wider interests of the state. Right? How do we capture that balance in a way that gives voice to the legitimate interests of both groups and individuals, but also of the state's own understanding of what it means to be neutral? Now that's one form of balancing that Justice LeBel raised. There's a second question, and it's a question that is related to this general issue of balancing, but it is also runs through the various presentations, and that is the relationship of individuals and groups within religious freedom. Right? So how should we understand religious freedom? Is it primarily about the protection of individual conscience, right? Individual belief? Or is it related to something larger? Father de Souza points to a public good. Justice LeBel, I think, asks whether or not we should think of religion in its collective sense as primarily facilitating or serving the interests of individual rights, or something else. So that's Justice LeBel on balancing. Now, Justice LeBel also raises the question of what role for courts, right? And he does it in a very evocative phrase, right? What is this compromise? What is this balance that the courts have struck that he's participated in striking? The balance, he says, is the least imperfect world. It is one in which some religious communities will be deeply unhappy with the compromise struck, in which the state, in some instances, perhaps Father de Souza's description of the Quebec ministry, will be unhappy in other situations. But what Justice LeBel seeks through the doctrines of the court is to strike what he calls an imperfect balance. And he thinks that it is the role of the courts to attempt to strike this balance. So concerns about balancing and the role of the court. These concerns also arise in Professor Kislowicz. I'm just going to use Howie. Okay. We'll say Howie.
Yeah.
And Howie's great presentation. Right? And Howie's presentation turns on what seems to be a kind of technical debate in law. And we were warned against presenting merely technical debates in law. But I think this question about what constitutes a trivial interference, on the surface, it seems small, right? But it's huge, because it goes to the very heart of what we understand freedom of religion to be, right? And so, on the question of balancing, right? The question of balancing that Howie raises is this issue about at what stage should we look at examine closely the importance of religious, or the content of religious faith, right? Should we look at it when we're defining what a religious faith is, right? So that is sort of countered by the Supreme Court's jurisprudence, because the Supreme Court's jurisprudence really does focus on the individual conscience, the individual belief, right, and their sincerity. Right? Should we do it there at the point of content? Or should we do it at the point of interference? Should we say, as Howard says, should we look and say, look, be reasonable on this, right? Don't be unreasonable at what your faith requires, or what protection your faith requires. Be reasonable with this at the point of interference, right? And so that's, again, a balancing between what the individual faith is, right, and at what point it can be interfered with, right, and how to define the boundaries of faith. Now, this also raises the question of institutional competence, about where the court should do it, because, and if you're not a lawyer, feel free to just think about other things for a few seconds, right? But there is an issue here, right, about at what stage should the court undertake this exercise of balancing to determine whether or not the religious practice, religious faith, right, should be protected. You can do it at the point of definition, right, inside of the analysis of the religious freedom itself, right, and that has implications, right, because at that point, the religious claimant, bears the burden of showing violation. Or you can do it at the point of balancing, right, at the point of justification in the Canadian system under Section 1. And at that point, the state has the burden, right? So this construction within the courts of where the balancing happens is incredibly significant as a matter of constitutional law because of where it allocates the burden of proof. Okay. So I'll close now with Father de Souza's excellent presentation. And I'll return to this question of individuals and groups that I raised very briefly in my discussion of Justice LeBel's discussion about religious freedom. Now, Justice LeBel said there's this kind of question as to whether or not individual religion, right, religious beliefs should be defined individually, or whether they should be defined as a group. And I said that in Justice LeBel's interpretation, it's possible to understand him to be saying that the group primarily sustains the individual's practice. Right? We cannot practice our religious belief unless we have the group to sustain us in some way. Right? Now, I think that Father de Souza offers a stronger version of this claim. Right? He's not saying that it's simply enough that the individuals do that kind of sustaining work, although in his discussion of Carter, he says that is one role of the religious communities. Right? But it is also important to note that religious communities constitute a public good, right, in and of themselves, independent of any sort of pursuit of individual goods, right? But in and of itself, religious faith and religious communities contribute to the public good. Okay. And so the question, I think, underlying Father de Souza's presentation is a question of at what point and how should the state balance the interests of that public good, that servant of public good, the religious communities, and the state's definition of public good. And I'll close now with the role of the courts in Father de Souza's presentation, right? There is a concern in Father de Souza's presentation about the capacity of the court to do something like what Justice LeBel praised, right? Justice LeBel said that the courts find a way to strike an imperfect, right? A balance that yields to the least imperfect world, right? Father de Souza views the matter quite differently, right? He says that what the courts are doing is fashioning for themselves what a societal consensus is, commandeering for themselves away from the legislatures, and away from broader communities and the larger society. Right? And Father de Souza says it's an inappropriate role for the courts. So, 3 presentations revolving around questions of balance in various guises and the appropriate role for courts. I open the floor to your questions.
Thank you very much.
Well, I just wanted to make a remark about some of the observations of Father de Souza about, I would say, I agree with him that religions are a common good, but I'm less comfortable when he says that we should prioritize belief compared to non-belief, unbelief, or disbelief. I think a system of freedom of religion, freedom of opinion, freedom of conscience has to treat those options equally if we want everyone to share equally in the life of society. And I think in the interpretation of the Canadian Charter, of the sections, especially on freedom of religion and freedom of conscience, it's impossible to create a hierarchy of beliefs in this sense by saying that some forms of belief are deemed to be preferable in some way to the contrary approach of not believing or having other options. And I would have an additional concern because this would lead us into the consideration of what is religion. If we went that way, we would have also to inquire more in depth into what is religion, what forms of religion would be acceptable as part of this public good.
Thank you.
Would these be only the three monotheistic religions, Abrahamic religions? Would other faiths be considered for this purpose? We see sometimes in other jurisdictions that courts have to get into those issues. We have seen this in England recently.
Thank you. For those of you who worry about arbitrary power, we see in Professor Farrell's elimination of our break, it's like administrative discretion. We should appeal to the justice on that.
And that's both administrative and constitutional, I bet.
Not unreasonable is the working hypothesis here, okay. Well, I'm very grateful for Justice LeBel's presentation in the first instance and this comment because it leads into what I wanted to respond to in his presentation. It is true that it becomes very complicated. What's religion, which religions, what constitutes religion. My main point was simply is that to be neutral between religion and irreligion or belief and unbelief is just very difficult to do. And in fact ends up with the court usually choosing one metaphysic over another, but that's, I guess we can continue that discussion if the questions come up. But in his original presentation, what I found quite intriguing was his treatment of his formulation that freedom of conscience is something that will need to be developed. And I actually have the opposite view, but really similar outlook for the future than he does, in that I think actually freedom of religion has been treated almost exclusively as freedom of conscience. By that I mean that it's an individual position that's held and then worthy of respect, which at least in the Christian tradition is more like conscience than religion, which implies a body of teaching, a body of doctrine, a body of believers, some kind of tradition. So I actually think what's happening now, starting with Loyola especially, but to other cases that were mentioned, is that the court is actually going to have to figure out what is freedom of religion. Freedom of religion that includes things like common expression, common institutions, etc. Because it's not enough to say it's simply a deeply, sincerely held belief. That's more to me like conscience. So I think where the jurisprudence is going to be developing in the years ahead is on what constitutes freedom of religion, and that's where my principal point, I think, comes to the fore, is this religion then a public good? And is that why it's defended or enumerated in the fundamental freedoms? And in the Loyola case, I think it's very clear that the government's position was that it's not a public good. It's actually a public threat, and the court disagreed there. So although whether it's freedom of conscience or freedom of religion, I think that difference, that move from privately held opinion to the richness of religious communities, common life, which includes doctrine and practice, is where the court will be wrestling with these issues in the next years.
I would take the liberty of the chair to add just one or two thoughts. We approached this day with quite a number of questions, and we've had some very helpful attempts to address those questions, some helpful analysis of cases and of philosophical issues. But I think it's clear at the end of the day that we have solved rather less in our society and in our discussions than we might justify a great deal of confidence. We have a lot of work to do. Justice LeBel has explained to us that the substance of the freedom of conscience is not entirely clear. One of our questions is how fundamental are the fundamental freedoms? Well, they can only be as fundamental as they are clear. We've just had a suggestion that perhaps we don't need the freedom of religion. Now, there will be very different views around the room about that. But again, when we ask the question, how fundamental are the fundamental freedoms? That doesn't suggest a strong positive response. So if we are uncertain about the content of freedoms we describe as fundamental, how I'm asking, do we get to clear and justifiable and even capable of commanding a consensus decisions about, for example, triviality, which Howard raised for us in a really helpful way. One of the problems in the Loyola case was whether a Catholic school could be Catholic part of the time rather than all the time. And the government's view and the appeal court view was that as long as they were able to be Catholic most of the time, it was a trivial infringement. Whereas, of course, many Catholics would say to be Catholic is simply to be Catholic. 1 second or 1 hour or 1 day, it doesn't matter. The 1 second violation is just as serious as the 1 day violation. How do we weigh these things up if we haven't a consensus about what the fundamental freedoms are? How do we do the balancing that Hoy spoke of if we don't know that? So when we come to Carter, for example, we have the question about how to uphold human dignity and human autonomy. But where do we get our view of human dignity from? Some people say it is not compatible with human dignity to take one's own life or to be helped in doing so. Others say it's essential to human dignity to have the autonomy to do that. Who decides these things? And on what basis do they decide? These are very, very difficult questions, and one of the purposes, I suppose one of the purposes we had in planning this day was to help bring them to light and help us realize how serious the challenges going forward are. Now, that's not to take away at all from the erudite and the generous attempts to delineate and, in some cases, to address these questions that we've had help with from all our panelists. But we particularly want to thank the present panelists, Justice LeBel, Father Souza, Howard Kislowicz, and Roy Kong. Please join me in doing that, and then you do a class.